Thank you for being here on behalf of the Tech Collective. We're thrilled once again to partner with Vertical 6. They've brought us some incredible high caliber speakers. And I know, having heard a little of Karyn's presentation for today, we are in for well, I'd say a treat, but I don't know. It may be some very overwhelming information for those of you who need to deal with these regulations. But Karyn Rhodes is from Complete Payroll Solutions, and she heads up Complete HR Solutions. She's a regional and national speaker. She's appeared on TV and radio, and we are thrilled to have her here today to present for us the most up-to-date changes in the legalities and regulations of reopening our businesses. So I know that even since 2 days ago, when we first did a pre-discussion on this, there's been some updates and some new information. So get your legal pad ready, I'll say. I think there's going to be a lot of note-taking for today's presentation. So thank you all for being here, and I'll hand it over to you, Karyn. Thank you.
Okay, thanks so much to Vertical 6 and Tech Collective for having me on today to talk about some legal considerations during this time, issues, and reopening your business as we see the state starting to reopen slowly, not quickly. So, there's several issues that are coming about. Employees are afraid of coming to work. So this is a common question that we're getting in. How do we deal with employees that are afraid? So they don't want to come to work due to fear. We want to get an understanding of why they're afraid to come to work. Is it they have an underlying medical condition? Are they in a certain age group that is more susceptible to getting COVID or dying from COVID? It could be an anxiety issue, or it could be they're making more on unemployment. So make sure that you're following guidance from the CDC, OSHA, with the state directives for infection prevention measures. First of all, that's very important. The states in the Northeast have released all of their guidelines. CDC and OSHA have strong recommendations for organizations, but it's the state directive that actually is the enforcement body. So make sure that you understand your state directives depending on the state that you're in, and we'll talk a little bit about that later. So strongly consider legal risks and seek advice before disciplining staff. So some employers have taken the strategy that if you're not going to come back to work because you're afraid, I'm going to fire you. That could get people into legal hot water. I'm going to walk through some of the legislation with you so that you understand how you need to triage different things. So the OSHA General Duty Clause and the NLRA protects employees from working in dangerous conditions. So if they have a reasonable...
Karyn, sorry, I'm so sorry to stop. Is there a way that we can see your PowerPoint? It was up in a minute and then I stopped seeing them. I don't know if all of you are able to see it.
Let me try again. I'm not sure what happened there.
It may have been me when I switched.
Let's see. Oh, okay, let me try again.
Thank you.
Bear with me just 1 second.
Yes, of course.
Here we go. There it is. Can you see that now?
It's loading. Hold on.
Okay.
Excellent. Thank you very much.
Good. All right. Sorry about that, everyone.
No, it's excellent. Thank you. I appreciate it.
Okay. So we were talking about the OSHA General Duty Clause and the NLRA. It protects employees from working in dangerous conditions. So if an employee feels like coming into work could impact their health, it could, in fact, kill them, they have protection under both of these statutes. So certain medical conditions are at higher risk for more severe illness, including death if they contract COVID-19, chronic medical conditions such as lung disease, serious heart conditions, diabetes, immunocompromising conditions such as cancer and autoimmune. Now, if they're not coming to work because they're making more on unemployment, that is a disqualifier for unemployment. So if they're recalled to work and they're not coming for that reason, and unemployment does an audit of them, and it's found that they were recalled to work, they're going to have to pay back all of the money they collected from unemployment and a 30% fine. And there's potential jail time for that. So if they're not coming back because they're afraid to come back to work, because they're in one of these age groups, or because they have a medical condition, you need to work with them on this and get into an interactive process. And it may be the best solution for them is to stay on unemployment for a while as we work through this period of time. If someone is sick, the typical process in Rhode Island is you would file for temporary disability insurance. Temporary disability insurance is allowing people with COVID positive on for 2 weeks, and then they want them to transfer over to unemployment. So just be aware of that. So this is a large federal statute, the Americans with Disability Act, or ADA, and this requires employers to reasonably accommodate employees that may have underlying medical conditions. It also could be that somebody has extreme anxiety. They would also be protected under this law. So request for leaves or telework due to increased risk for COVID is a request for accommodation. So they're very clear about this. If somebody's requesting a leave, you need to consider this law and consider that they are requesting an accommodation. And that accommodation may be that they're going to continue to work from home until a safe time exists for them to come back into the workplace. So you want to enter into this interactive process. And what that means is you have a conversation with your employees. They're asking you for the work from home or the accommodation, and you're talking to them about it. And you definitely want to document what the conversation was and what the accommodation was that you gave that employee. So it's no different than someone with any other physical or mental condition. Same process is in place. Okay. So employers can request documentation. We have a leave of absence form that they can use for medical documentation, but you can, in fact, ask them to get some medical guidance for you. So this is another big federal statute, the Age Discrimination in Employment Act, or ADEA. So this act does not require employers to reasonably accommodate older people who are requesting not to work as a result of COVID. Some states, as we know, are creating different rollout plans, and they are recommending that people over 60 years old continue to work remotely. In fact, most of the states in the Northeast, if not all of them, have said if you can continue to work remotely, you should be working remotely right now. So otherwise, employers should not treat older employers any differently than other employees. So for example, an employer should not target people 60 years old and older and lay them all off, or tell them that they can't come back into the work environment, everybody else can. Those people generally need to request that accommodation, and then the employer gets into that interactive process with them. Another big federal statute, and states again have their own statutes on pregnancy discrimination. We have had many, many cases of employers thinking they're helping their pregnant employees by laying them off because they're afraid of their health or their baby's health. They cannot just be laid off because of COVID. So they need to be treated the same as any other employee. If a pregnant employee, however, requests an accommodation, the employer is going to get back into that interactive process with the employee and see if they can accommodate them. If they have a medical condition that may be covered by ADA, a reasonable accommodation and interactive process may be put into play. So pregnancy in and of itself is not a disability. And I know that a lot of people think they're doing the right thing because they're worried about older people, they're worried about pregnant employees and so on. But these statutes are very strong statutes, and you cannot take action against them. So don't lay off a pregnant employee because you're concerned about them contracting COVID-19. The employee needs to ask for an accommodation. You could get into a conversation with a pregnant employee and have a discussion with them about how they feel their safety is and so on and so forth. That's perfectly fine. And if they say to you, I'd like to work remotely because I'm concerned, see if you can accommodate that. So some other issues that we have, my employee does not want to come to work because they're afraid of catching COVID. I'm going to fire them and they can stay on unemployment. Similar to the last conversation we had, proceed with caution. So if the employee has underlying medical issues, is afraid of coming to work, they'll most likely be a protected right under Section 502 of the NLRA and the OSHA General Duties Clause and the ADEA. So we want you to dig in a little deeper and find out why the employee is fearful and attempt to reasonably accommodate. So communicate to staff the steps you're taking to make the workplace safe. So we're going to talk about the states releasing their guidance, but you definitely should have a COVID plan in place. You should be documenting everything that you do in regard to keeping people safe, and you should be communicating that frequently to your employees so they understand all the steps you're taking in the workplace so they don't have to be afraid to come to work. So I don't have work for my employees to do. Do I still need to rehire them? Interesting question. So under the PPP, if you have filed that and you have gotten that money, yes, you should be rehiring all of your staff and putting them back on your payroll for that 8-week period. And that 8-week period starts when you receive the funds from the lender. Okay, so everyone comes back on your payroll, even if they're not working, even if they can't work because their child's school is closed. Everyone's back on the payroll and they're coming off unemployment and you're paying them out of the funds that you got through PPP. Okay, you know, right now, if you use 75% for payroll dollars, you'll be forgiven on the loan. I'm hearing behind the scenes that that number may reduce down a little bit. We'll see what eventually happens, but that is the current process. Okay. I'd like to rehire my employee, but they're refusing to come to work. They're telling me that they will make more money if they stay on unemployment. So similar to our previous discussion, staying on unemployment when they have a valid job offer is not an option. So it's considered fraud. Each state has a fraud division and we'll be looking into this. So again, as I said, if they're audited, they're going to have to repay that, pay a fine and potential jail time. So it's not a good strategy for people to take. There may be an underlying reason why someone's refusing to come back to work and it may be covered under unemployment. But we just want to caution our employees about that. They would do a lot better if they came back to work, even if they're making less money, and now their job is secure going into the future. Unemployment is only going to last a certain amount of time and then it's over. And at that point, the employee is going to be separated from the employer. Can they find another job and so on and so forth? Just not a good strategy. So rehiring your employees. So we're recommending to clients that if you're going to rehire, you send a certified letter to the staff that you're rehiring with the recall date in it. And you want to keep a copy of that in the employment file. Then document what the employee is saying to you in regard to why they don't want to come back. Just make sure you have very good documentation in case that audit is done. Okay? So you're going to bring people back on your payroll as if there were no break in service. And we're getting a lot of questions on this. Should we put a termination date in our payroll file, so on and so forth? I would be against that because it's a temporary break in service. And the person really wasn't terminated. It was just a temporary break. So I would just put them back on as though there were no break in service. If employees were coming off benefits, they would go back on your benefit plans. Keep in mind your plan documents and the elimination period. Most providers today have waived that because of what we're going through. So employers should be able to put people right back on. If retirement plans stopped, they're going to restart. If your employees don't have regular work to do, you consider other project work they can help out with. So just be cautious of exempt employees that are working on non-exempt tasks. It may, in fact, cause them to lose the exempt designation under the FLSA, and so they would be considered non-exempt employees and then be entitled to overtime. So just be cautious of that if you're having them work on really non-exempt duties. So Form I-9 and rehiring employees. So USCIS right now has said that List B documents on Form I-9 can in fact be expired. So they realize that people's licenses are expiring and they can't go to the DMV to get them updated. So for this short period of time, they are allowing expired documents. So DHS will likely consider returning employees to be continuing in employment when they're rehired, and typically a new Form I-9 is not going to be needed. They should continue as though there was no break in service. And if you're required to use E-Verify, no new E-Verify cases should be opened as long as one was opened when the employee was originally hired. And so just a word on E-Verify. If you are not mandated to use E-Verify, you should not be using that system. Okay, we know that USCIS mines that system and they audit out of that system, even though they're saying that they don't. Legal counsel and I are on the same page with this. So you definitely don't want to be using E-Verify unless you're mandated to do that. Okay, employees who have documents that expire will need to provide new documentation to update Form I-9. Keep in mind in this time of COVID where people are working remotely, if you are hiring people, you can actually have your new hire go to a family member and have them complete Section 2 of the I-9. So they don't need to come into the office, okay? So the family member is filling out Section 2. The form is still going to come to the employer, and the employer is still responsible for compliance with Form I-9. So questions on the emergency paid FMLA, so the Coronavirus Relief Act, the FFCRA, we are still getting questions of this coming in. So if you have PPP, you are going to rehire everyone, whether they're working or not. So during that 8-week period of time, the FFCRA is not going to apply because everybody's on your payroll. So it can apply either prior to PPP or after PPP, okay? So the FFCRA covers employers less than 500 employees that have worked for the employer for at least 30 days. And this statute is running until December 31st of this year. So the statute provides emergency FMLA for employees out of work due to daycare or school closures. It provides 2/3 pay for 12 weeks. The first 10 days are unpaid, but the first 10 days you can apply for the sick leave portion of this and get paid. So there is a limit of this, $200 a day or $2,000 if they're caring for other people. So that's the emergency FMLA portion of the FFCRA. Again, it would apply after PPP ends. Up to 2 weeks of sick leave, 80 hours if they need time off to quarantine, isolation, they're symptomatic, waiting for a diagnosis. And there is a limit on this also up to $511 a day or $5,110 per employee if they're taking leave for their own well-being and so on. So that sick leave is granted to all employees. Typically, they should take it prior to using their own paid time off. Policy is definitely the first revision of the House bill mandated that the 80 hours come first. The Senate loosened up on that, but it's still a good idea to have them take that first. This time, by the way, will be reimbursed to the employer via tax credits. So you need Form 7200, complete that to get the tax credits for the amount you're paying. So as we know, a couple of weeks ago, the federal government had opening up America again and their guidance to all the states. So at this point, the states, most of the states have put out reopening plans and guidance. I was hoping that the Northeast, New Jersey, New York, Connecticut, Rhode Island, Massachusetts would all get together and release their own plan together as a group. Unfortunately, that hasn't happened. So each state now has put out their own state mandate. So if you're located in multi-states, you are going to have to stay up to speed on what that state is mandating. So at the federal level, they released federal guidelines for opening up business in the states. If you've seen the news this morning, the federal government did not take the CDC guideline in the open up process. So now there's a lot of chatter about that, again, conflict with the CDC and the president's office. So the ultimate responsibility and onus is placed on the governors. The governors and the state mandates will be the enforcement bodies for the plans that they put in place. So some of the states have 3-phase processes, some have 4, based processes. They're really looking at the science and the scope of the outbreak in the individual states. States are encouraged to base their decisions on data. So that's what they need to do. I know many of the governors are looking at that very carefully. So states should move to the first phase of reopening after exhibiting a downward trend of documented cases or positive tests over a 2-week period. I know that there's a lot of concern with the CDC because most of the states that have opened have not seen that downward trend for 14 days. So there's a lot of concern there. States are encouraged to move into other stages after showing that cases are not surging. So here are the phases. This is the federal level, and it's almost irrelevant now because each state, you'd want to look at your state and what the phases are that your state has. But at the federal level, they saw phase 1 as opening movie theaters, restaurants, sport venues, places of worship, gyms, other venues that could open with strict social guidelines in place. So in our Northeast states, movie theaters are not open, sports venues are not open. Places of worship, I'm hearing that they may begin to open with strict guidelines. Gyms are not open. Restaurants outside are starting to open, but those strict distancing guidelines are in place. So bars continue to be closed, schools continue to be closed, daycare centers are starting to open. There's some opening June 1st with strict guidelines. During this whole process, vulnerable people, older people are still going to be asked to remain home during this phase. Again, if you can work remotely, work remotely. Visits to nursing homes and hospitals are prohibited in the Northeast states. Some people could return to work in phases. Telework is still encouraged. Now here's phase 2. Again, this is the federal level. Non-essential travel would resume. Bars can open with some restrictions. Schools, youth activities can reopen. Pay attention that phase 2, again, vulnerable people and older people are still going to be asked to work remotely. Visits to nursing homes and hospitals will still be prohibited. Telework is still going to be encouraged under the plan. Phase 3, there's no restrictions on workplaces. Vulnerable people can resume social interactions, but should follow social distancing. Visits to hospitals and nursing homes can resume, and bars can increase standing room capacity. So we are not sure when these phases, either at the federal level, at your individual state level, are going to go into play. Again, it's going to be, they're going to be watching the science, watching the numbers, and then making those decisions as we go along. So I have done extensive work on the plans in all the Northeast states. New York has probably the most stringent, very well put together plan to reopen. Only 4 industries right now have been released, but they've done a very good job. Connecticut also has put out, Connecticut and New York have a certification process with the state, so employers will have to go through the guidance and then certify that they are in compliance with the recommendations. Rhode Island has a COVID control plan template that all employers need to fill out. If there is an exposure, not if, when, or the virus is traveling in your workplace, the Department of Health in Rhode Island and the state will be coming in and they'll want to see your control plan template and all the steps that you've taken to make your employees safe and make your workplace safe. So if they find that you haven't done the required things, I haven't yet heard of fines, but I'm quite sure that that is coming. Regardless of whether employers are mandated to take these steps or not, every employer should be taking these steps to make sure that they're providing protection for themselves if there's an outbreak and if people die in their workplace. So I'm recommending to companies that they create a COVID documentation file and they keep in there every step that they've taken to protect their employees. Do they have posters that are required in the Northeast states? Have they done training to people? The face masks and so on. If you go through the control plan, it will walk you through everything that you need to do. So Rhode Island has also released Rhode Island Reopen Guidelines. Posters, last night, breaking news, they came out with a Crush COVID Rhode Island app. So you can go into your app store and download that, and it's Crush COVID Rhode Island. So there are some privacy concerns with it because the Department of Health wants us to allow tracking so they can track where everybody's going. And there's a little check-in guide for your health. They want you to put in your zip code. Are you feeling well? Are you not feeling well? Again, they're trying to look at the science behind this and make sure that everybody's safe. I understand the privacy concerns, so people are going to have to think about what they do with that. Rhode Island has also released business guides, an employer guide, and an attestation poster. So that is the state of Rhode Island. I'm not sure if anyone's in Massachusetts. So Massachusetts released their regs on Monday, and I have to tell you that I was pretty shocked to see the lack of guidelines, the lack of restrictions in Massachusetts. I'm very, very concerned that people are going to be spreading the virus rapidly. In that state, employers cannot force employees to tell them if they're sick or experiencing symptoms. So employees can, quote, voluntarily disclose. So you could have people coming into the workplace and spreading this. And I'm just very concerned about that process. Now, employers can always do more than what the state is asking. I strongly recommend that they put in much more stringent guidelines that the state of Massachusetts is asking for. I definitely would do medical screening using a medical questionnaire. We have trainings for medical screeners and so on, and return to work toolkits. But the medical screener definitely has to have proper PPE, and they should definitely be trained on how to store the medical information they're getting and how to keep themselves safe. So this is the medical screening protocol. Now, in the state of Massachusetts, they're not requiring this. I, again, would strongly recommend that you put in some type of medical screening protocol and require employers to screen all employees, vendors, anybody that's trying to come into the work environment. So what we should do is think of the work environment as a secure place. We don't want any contaminated people coming into the work environment, and that's why we want to go through this screening. So if anyone asks or checks off yes to any of the questions, do you have a cough, sore throat, have you traveled domestically within the last 14 days or internationally, do you have a fever? If you check off yes to any of those, you won't be allowed into the building. You'll have to get guidance from the company, self-quarantine for 14 days, and so on. So we're trying to keep our workplaces secure and free of the virus. We know that people that have no symptoms are going to be coming into the work environment and may spread it. So as soon as somebody is symptomatic, we want to make sure that we are closing off that area. We're isolating that person, getting them out of the work environment, having them contact the Department of Health and the doctor right away, go through a sanitizing process. A lot of organizations are then sealing off that area for a couple of days before allowing anyone else to go in it. So we have toolkits and trainings for employers on medical screenings and return to work so that people do this in compliance. So it's not as easy as, flicking the switch on and everyone coming back to work. There's significant protocols that people have to go through. I have an office in Rhode Island, and I'm going to have to go through this control plan as well before anybody comes back into the office. So this is impacting all of us. So I'm happy to take any questions that you have.
Sure. Karen, Lauren had asked, are employees required to tell employers if they are sick and or COVID-19 positive in the state of Rhode Island?
Yes. So they are, in fact, and part of your plan, you definitely want to get that communication out to your employees. And I have a sample that I could share with people, but it's a notice to your employees telling them that everybody's going to go through this screening process before coming into the workplace. So some employers are concerned about the reporting pay for non-exempt employees. So I report to work. I'm not allowed to come in the door because I'm symptomatic, get sent away, and I get paid for 3 hours. So the process should be, before you even go to work, employees should have the checklist. They should indicate if they're symptomatic or not. They're going to take their temperature. And if they check yes to any one of those questions, they shouldn't be leaving the house. They should not be coming to work. So you really shouldn't have many or any people arriving at the workplace that all of a sudden develop symptoms when they're driving there. So you want to just indicate to them, if you're symptomatic, you cannot come in the building. You should not even be coming to work.
Jonna had put forth of what if it's a Massachusetts company and a Rhode Island employee and vice versa.
Mm-hmm. That's going to be interesting, and we are getting questions about this. So so there's two questions. If they're multi-location, they're going to have to look at all of the states they're located in and come up with a plan to satisfy all of those states. So if you're an employee that lives in Rhode Island and you're going to a Massachusetts company, again, the regulations there are not as strict, and that may give you some concern, and you may not want to go to work as a result of that. So you're going to have to talk to your employer about that, and I'm hoping that employers will put in a much more rigorous guidelines so that their employees feel safe. Coming from living in Massachusetts, coming to Rhode Island, the guidelines are pretty strict and enforceable. So I would think that people would feel a little bit safer once they know what their employer has done in order to protect them. Any other questions that you have?
So nothing else is coming up on the chat. I did put in there where you can find the Crush COVID Rhode Island app if anyone is interested. So that information is up there.
Great.
Well, if no other questions, certainly thank you so much, Karyn, for all the information that you imparted to us today. Karyn's information is up, and please copy it down. This is what she does, and is here to answer these questions. So we just have one more. It's, can you share the screening notification for employees that you mentioned earlier?
Yes, I can. How would I get that? You can either email me directly. Why don't you do that? And then I'm happy to send you that note to your employees. So just a side note, just quickly. So the medical screening that we are doing, we are making sure our medical screeners go through HIPAA training and ADA training so that they completely understand the sensitivity of that data and how information needs to be stored. So just consider that if you're doing medical training on your own.
Right. Like afraid to say goodbye that something else is going to pop up, but it's quiet for a few seconds. So thank you, Karyn, for all of your information, and to Jonna and the team at Vertical 6 as well for helping us put this together. We hope that you've enjoyed the presentation and certainly that you've gotten the information that you were looking to receive today.
Okay. Yeah, thank you, everyone.
Thank you.
Thank you so much.